The new PAGA also introduces significant relief for employers who can demonstrate good faith compliance with the labor code. This is your key to reducing penalties, potentially by up to 85% or more. And here's what you need to do. Hello, I'm Anthony Zaller. I'm a California employment defense attorney. I've been practicing law for over 20 years here in California. And today I want to discuss what the Reformed PAGA means for California employers here in 2024. California's labor laws are changing. And if you're an employer, there's one key reform you need to know about: the changes to California's Private Attorneys General's Act, or PAGA. Stick around as we break down what these reforms mean for you, and most importantly, how you can protect your business from costly penalties. First, a quick overview. PAGA allows employees to sue their employers on behalf of the state for labor code violations, essentially stepping into the shoes of the labor commissioner. It has been a major headache for many businesses in California, often resulting in significant penalties even for minor infractions. In June 2024, California reformed PAGA to give employers a break from these harsh penalties. And here's what's new. Number one, stricter standing requirements for plaintiffs. This means that now employees have to prove that they experienced or suffered one of the allegations or violations that they're alleging in the lawsuit in order to recover a penalty. In the past, they only had to show that they suffered from one penalty, and then they could sue on behalf of all employees for all penalties that they alleged the employer committed against all of the employees. Number two, reduce penalties for minor violations. Under the revised PAGA, penalties for technical mistakes, like minor errors on wage statements, are significantly reduced. Number three, there's a cap on penalties for good faith compliance. Employers can cap the penalties down to 15 or 30% of the original penalty if they can show that they're taking proactive measures to comply with the labor code. This is a huge benefit for California employers, but they do need to take affirmative action to prove that they're taking good faith efforts to comply with the labor code. Next, we're going to move on to the new standing requirements. One of the biggest changes is the new standing requirement. Previously, an employee could sue for multiple violations, even if they only experienced one themselves. Now, under the reformed PAGA, they must have personally experienced each type of violation they want to claim. They can't now claim they only suffered one violation and bring a lawsuit on behalf of all employees for multiple violations that they never themselves individually suffered. This narrows the scope of the claims, which also reduces the number of lawsuits, or at least makes them more manageable under this revised PAGA. I also want to talk about the major benefit that California employers have under the reformed PAGA. It's the reduction of penalties. The new PAGA also introduces significant relief for employers who can demonstrate good faith compliance with the labor code. This is your key to reducing penalties, potentially by up to 85% or more. And here's what you need to do. Number one, conduct regular payroll audits. So this is reviewing common wage and hour issues, such as meal and rest breaks, that employees are taking the meal breaks and clocking out for them on time and taking a full 30 minutes. That your policies are correct, providing for the correct timing of the number of meal and rest breaks. And also that you're issuing wage statements, and those wage statements are correct and comply with Labor Code Section 226. And also, finally, making sure your records are accurate and up to date. Number two, employers have to have lawful written policies. This goes without saying. Employers need to be updating these policies and ensure that they're compliant with the labor code. And this goes a long way to opening up this reduction in penalties under the reformed PAGA. Number three, employers need to train their supervisors. It's not enough just to have a compliant policy and to be auditing those policies. Employers need to take the next step and make sure that their frontline managers and supervisors understand what these obligations are under the labor code and are actually training those managers and supervisors to ensure that they're complying with the labor code and that they're complying with the company's policies. Number 4, and finally, employers need to take corrective actions. So if there is a manager that makes a mistake or maybe intentionally does something wrong and violates company policy or the labor code, employers need to discipline those managers or those supervisors, document that discipline, and make sure that that activity doesn't go beyond that one instance that the employer knows about. This goes a long way in showing good faith compliance with the labor code and can cap the penalties under this reformed PAGA. These actions not only cap penalties, but also demonstrate a proactive approach, which courts view positively. Another reform that I want to mention under the revised PAGA is the amount of judicial discretion and the ability the trial judge has to manage PAGA cases. In the past, it was up in the air and not entirely clear how much authority judges had to manage these PAGA cases and limit the claims. Under the revised PAGA, judges have a lot of discretion, and they now have greater authority to limit PAGA claims and to ensure that these cases are manageable. This means that the cases can be less expensive and less time-consuming in litigation. In addition, courts have the ability to reduce penalties even further under these capped penalties if employers can show good faith compliance with the labor code. It's entirely up to the trial judge to have this ability to reduce the penalties even further if they believe the employer was acting in good faith, the penalties were technical, or maybe there was no actual injury by the employees alleging certain labor code violations. So this is significant in reducing the amount of penalties that employers may face under the revised PAGA. So finally, what's the key takeaway for California employers under the reformed PAGA? It means that there's more ability to resolve these PAGA cases early. And if employers have arbitration agreements in place with a class action waiver, which are still recommended, it limits these types of claims to PAGA only. And with the revised PAGA, employers face drastically reduced penalties if they're taking these good faith efforts to comply with the labor code before these claims are brought against them. So in summary, California's PAGA reform is great news for employers. It offers clear opportunities to limit liability and focus on compliance. Make sure you're conducting regular audits, training supervisors, updating your policies, implementing arbitration agreements that are enforceable, and this will ensure that you benefit from the reduced penalties under this revised PAGA. Thanks for watching. We're going to have a lot more content about what this revised PAGA means for California employers going into 2025. If you have questions or want to dive deeper into PAGA compliance, leave a comment below. We'll be covering more updates about California employment law and what this revised PAGA means for California employers in future videos.